Hello. Thank you for joining us today for a KHC training. My name is Paula Howard. I am the ERA Technical and Quality Assurance Specialist with the Housing Contract Administration Department of Kentucky Housing Corporation. Joining me today is Kathy Likens, Compliance and Training Technical Manager. This training is on the VAWA HUD requirements. VAWA is an acronym that stands for Violence Against Women's Act. Although the title indicates this act is for women, this law protects both men and women alike. Don't let the name fool you.
What is the Violence Against Women Act? The Violence Against Women Act, or VAWA, creates and supports comprehensive, cost-effective responses to domestic violence, sexual assault, dating violence, and stalking. Up for renewal every 5 years, each VAWA reauthorization builds on existing protections and programs to better meet survivors' needs. The Violence Against Women Act is U.S. federal legislation that was initially signed into law by President Bill Clinton in September 1994. The original VAWA was enacted as Title IV of the Violent Crime Control and Law Enforcement Act. Since its original inception, the regulation has seen several expirations and reauthorizations, most recently reauthorized as part of the Consolidated Appropriations Act of 2022. The VAWA regulation provides many protections, programs, and services. However, in this training, we will only concentrate on HUD's requirements related to the VAWA legislation. HUD issued a final rule in 2016 that provides requirements on how HUD requires its funded agencies to address certain VAWA requirements. You can find general HUD VAWA requirements by Googling 24 CFR 5.2001 through 5.2011. This is what this training will discuss: HUD's rule on how funded agencies must implement VAWA requirements.
Which programs are required to adhere to HUD's VAWA guidelines? Home TBRA, Emergency Solution Grant, ESG, Continuum Care Programs, CLC, and Housing Opportunities for Persons with AIDS, HOPWA. There are many other programs that have to follow VAWA rules. The ones in red are administered by Kentucky Housing. The ones in black are also required to follow the rules. Who is protected? It should be noted that although VAWA refers to women in the title, the statute makes it clear that the protections are for all applicants and tenants, regardless of sex, gender, identity, sexual orientation, or age. VAWA provides protection to all people who are victims of VAWA. Here are just some examples of what is listed under each category: domestic violence, emotional abuse, physical abuse, economical abuse, psychological abuse, isolation.
Dating violence, physical abuse, threats, coercion, sexual abuse, intimidation, emotional abuse.
And sexual assault. Non-consenting sex, unwanted sexual touch, fondling, forcing sexual acts, attempted rape.
Stalking is engaging in a course of conduct directed at a person that would cause fear to their safety or causes emotional distress. This can be in the form of text, calls, emails, etc. VAWA laws are also provided to affiliated persons, such as a spouse, current or former, parent, brother, sister, child of the victims, or a person to whom the victim stands in place of a parent or guardian. Any individual, tenant or applicant, or lawful occupant living in the household of that individual. For parent or guardian, it can be the person in care of custody. Your new VAWA policy must support and or assist victims of VAWA crimes and protect victims, as well as any affiliated person, from being denied housing or from losing their HUD-assisted housing because of their status as a victim of VAWA crimes. The VAWA final rule provides that an applicant or tenant may not be denied assistance or have assistance terminated under a covered housing program on the basis of or as a direct result of the fact that the applicant or tenant is or has been a victim of domestic violence, sexual assault, or stalking. This is located at 24 CFR 5.2005, paragraph B1.
Please be sure to read the VAWA section of your program rules, as there are special consideration and timeframes that differ between programs. The programs that KHC administrates relate to the VAWA rules are listed in the red. VAWA does not limit an agency or landlord's rights to terminate assistance and or tenancy for any violation that is not related to VAWA crimes. However, the landlord must not subject the victim or a person affiliated with the victim to a more demanding standard than other tenants when determining whether whether to terminate assistance or tenancy. VAWA does not limit an agency or landlord's rights to terminate assistance or attendance if the agency or landlord can demonstrate an actual or forthcoming threat would be present if the resident or lawful occupant is not terminated, such as threats to other tenants, employees, vendors providing services. This could be words, gestures, actions. Actual and forthcoming threats refer to physical danger that is real, would occur within immediate time frames, and can result in death or serious bodily harm. To determine whether an individual would pose an actual or immediate threat, the factors to be considered are duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the length of time before the potential harm would occur.
For VAWA HUD required documents, required documents can be found in the toolkits at the HCA Partner Agency Portal, previously known as the HCA Help Desk. For each program type that is required to follow VAWA, the toolkit will have the required documents. The link to the portal is https://kyhmis.zendesk.com.
Who and when you should provide forms to. Every applicant when admitted to program, every denied applicant, every current tenant, every client at recertification and unit transfer, every client at termination.
HUD Form 5380, Notice of Occupancy Rights under the Violence Against Women Act. This is the form to give each client. Your agency must fill in the boxes with the missing information that pertains to your particular agency and your particular area. HUD Form 5382, Certification of Domestic Violence. This is the certification of domestic violence. This is the form you can have the client document the incident on, but it is not required. Agencies must take the information however the client presents it to you. This can be on a handwritten note, slipped under your door, in a phone call, in person. HUD Form 5381. Every housing agency or partner that works with emergency or rental housing must have an emergency transfer plan that describes how your agency will work with the client to obtain suitable arrangements should they need an emergency transfer. HUD has taken the guesswork out of by creating a form that has fill-in-the-blank spots to indicate your plan. HUD 5381 is a requirement for all KHC programs that deal with rental or emergency housing. HUD 5383 is available to be used when a client is seeking an emergency transfer. Just like the other request form, this form is available but is not required. You should accept this information in any form that is provided to you from the victim.
Seeking VAWA protection. When a person indicates that they are a victim of VAWA crime and states that they want to invoke their protection, the agency and/or landlord must take certain steps. Certification as a victim of VAWA crimes does not require an agency or landlord to request that an individual seeking protection submit documentation of that status. If an agency is going to require certification or other documentation, requests for documentation must be in writing and must conform to the rules of timelines described. HUD stresses this point in the final rule.
To document the occurrences of a VAWA event, the person seeking protection can complete, sign, and submit the VAWA certification form HUD 5382. Agency and landlords must allow at least 14 business days from the date of the request for this information to be returned. Agency and landlords may provide additional time, but may not provide less time. This certification may be submitted in an equally effective manner as a reasonable accommodation if there is the presence of a disability. If an applicant or tenant has sought assistance in addressing DV, dating violence, sexual assault, and/or stalking from a federal, state, local police or court, the resident may, but is not required, submit written proof to this outreach in lieu of the certification form. Examples of are police reports, protective orders, and restraining orders. Documentation signed and attested to by a professional from whom the victim has sought assistance is addressing any of the above acts of abuse. A professional is an employee, agent, or volunteer of victim service providers, an attorney, or medical personnel. The documentation must be signed by the professional from whom the victim sought assistance related to a VAWA crime, signed by the tenant, and that specifies under penalty of perjury that the professional believes the occurrence of the incident of a VAWA crime is the grounds for protection and remedies under the VAWA final rule. Also, if the resident is currently living in a shelter established to protect victims of domestic violence covered under VAWA, the agency or landlord should accept the verification of such living arrangements in lieu of additional documentation. If a covered housing provider receives documentation that contains conflicting information, including certification forms from 2 or more members of a household, each claiming to be a victim and naming one or more of the other petitioning household members as the perpetrator, the covered housing provider may require an applicant or tenant to submit third-party documentation as described in the previous 2 slides, within 30 calendar days of the date of the written request for the third-party documentation. The covered housing provider must make this request to the client in writing. Remember, a victim is not required to name the accused perpetrator if doing so would result in imminent threat, or if the victim does not know the name of his or her accused perpetrator. A covered housing provider is an agency or landlord receiving HUD funds, such as you folks.
Confidentiality. Victims have a right to privacy when dealing with the agency and/or landlord regarding VAWA report. All information provided by the resident must be kept confidential and must be maintained in a separate file. The identity of the victim and all information provided to the agency or landlord related to the incident of a violence must be retained in confidence by the agency, landlord, and must neither be entered into any shared database nor provided to a related entity, except to the extent that the disclosure is
requested or consented to by the individual in a time-limited written release, required for use in an eviction proceeding or termination of assistance, or otherwise required by applicable law. VAWA accommodations. VAWA accommodations, what does the applicant or tenant want from you, the agency or the landlord, to do to help them? Well, waive tenant selection criteria, such as maybe a credit screening, reconsider a rejection they have received, modify a lease term, for example, waive the requirements to provide a 30-day notice to move, reconsider a lease violation, reconsider a termination of assistance or tenancy, evict a member of the household or bifurcation, and emergency transfer. Please note that you are not required, nor in some cases authorized, to waive eligibility rules for one of your programs. Most agencies and landlords will consider each request on a case-by-case basis. Ensure staff remember to provide the same opportunities to all people seeking VAWA protections consistently. In order to set appropriate expectations, agencies and landlords should define in writing how they will respond to requests for VAWA accommodation requests. For example, the agency may want to include language such as how they will review, respond, and the time frame for responding, and that should be no more than 10 days from receiving all documentation. Responses may include approval of the request, denial of the request, requesting additional information. If the request is denied, the person seeking VAWA protections will have the right to appeal. Request to appeal must be received within 10 business days of the date of the denial. If appeal is requested, the appeal will be held with someone who was not involved in the original decision to deny.
There are a few VAWA accommodations that require a little bit more in-depth discussion. The option to bifurcate the lease, continue eligibility of remaining household members, and emergency transfer. We will dive in and learn a little more about each one. First up,
lease bifurcation. If the agency or landlord determines that the physical abuse caused by a resident is clear and present, the law provides the agency or landlord the authority to bifurcate the lease, meaning remove, evict, or terminate assistance to any accused perpetrator, while allowing the victim who lawfully occupies the home to maintain tenancy. Even in these cases, you may not require that the person seeking VAWA protections provide verification of their status as a victim of a crime or person affiliated with someone who is a victim of a VAWA crime. Remember, it is the person seeking protection's choice of which form they will submit, not yours. Except for cases where there is conflicting evidence, the agency or landlord may request in writing that the applicant or tenant submit specific documents within the 30-day calendar days of the written request. You may attempt to evict the accused perpetrator, but applicants and tenants should know that state and local tenant laws may prevail, and agency and landlords must comply with those laws. Tenants must keep in mind that the eviction of or the termination action against the individual must be in accordance with the procedures prescribed by federal, state, and local laws. Evictions are generally carried out through the court system, and the agency or landlord cannot override or circumvent a legal action. In the event that one household member is removed from the unit because of engaging in acts of violence, an appropriate research must be processed reflecting the change in the household composition. Agency and/or landlord may also establish policies to execute a new lease or to provide HUD an approved lease addendum. Special consideration will be given if the remaining household members are not qualified to remain in the unit or was not the qualifying household member. In some cases, when a tenant leaves a unit, the agency or landlord is required to determine if remaining household members are eligible for subsidy or for housing. The agency or landlord must determine eligibility of remaining family members when the qualifying member leaves. Please check your specific program, such as your ESG rule, your TBRA rule, your HOPWA rule, or your COC rule, for timeframes related to this eligibility determination.
In standard cases, the agency landlord is required to provide a 30-day notice of termination of tenancy or assistance. If the accused perpetrator leaves the unit or is terminated and was the eligible qualifying tenant under the covered program, the agency or landlord will provide 90 calendar days from the date of bifurcation of the lease to any remaining tenant that were not already eligible to establish eligibility for the same covered housing program under which the evicted or terminated tenant was covered, establish eligibility under another covered housing program, or find alternative housing. The 90-day calendar day period will not be available to a remaining household member if the statutory requirements for the covered housing program prohibit it, such as if your ESG or COC rule prohibit this, then they would not be eligible for the 90-day. You will have to check your actual rule to find out if this applies. It will not apply beyond the expiration of a lease unless this is permitted by your program regulations. The covered housing provider may extend the 90-day calendar period up to an additional 60 calendar days unless prohibited from doing so by statutory requirements of your covered program, or unless the time period would extend beyond the expiration of the lease. If there is no governing time frame and the remaining members are party to the lease and are of legal age to sign, we assume that person may remain in the unit and continue to receive subsidy for at least 90 days and potentially for an additional 60 days unless the lease expires. If you have a client that is being bifurcated from the lease that was the qualifying person on the program and the remaining household members do not qualify for program on their own, you will need to submit a request to the HC Help Desk so KHC can help you work through that process. Emergency transfer plans, ETP. Agency landlords must develop and implement an emergency transfer plan. It should include policies for assisting a tenant who is seeking an external emergency transfer under VAWA out of the agency and or landlord's program or project. A tenant who is seeking an external emergency transfer under the VAWA into the agency landlord program project. And that has got an error in it. It should say internal emergency transfer plan.
Okay, so let's define internal transfer and external transfer. For internal transfers, this refers to an emergency relocation of a tenant to another unit where the tenant would not be categorized as a new applicant. That is, the tenant may reside in the new unit without having to undergo an application process. An external transfer refers to an emergency relocation of a tenant to another unit where the tenant would be categorized as a new applicant. That is, the tenant must undergo an application process in order to reside in the new unit.
What is considered a safe unit? A unit that the victim believes is safe. It is victim-centered.
Qualifications for transfer. This is if the tenant requests a transfer, if the tenant reasonably believes that there is a threat to imminent harm if they stay in the same unit, if the tenant is a victim of sexual assault. The tenant may also be eligible to transfer if the assault occurred on the premises within the 90-day calendar period preceding a request for an emergency transfer. This is true even if the tenant is not a tenant in good standing. The tenant's submission of a written request to the agency or landlord where the tenant certifies that they meet the criteria shall be sufficient documentation of the requirements.
Requirements for ETP. The VAWA ETP must allow the tenant to make an internal emergency transfer under VAWA when a safe unit is immediately available.
The ETP must describe policies for assisting a tenant in making an internal emergency transfer under VAWA when a safe unit is not immediately available.
ETP must describe reasonable efforts that agency or landlords will take to assist a resident who wishes to make an external emergency transfer when a safe unit is not immediately available.
Nothing may preclude a tenant from seeking an internal emergency transfer and an external emergency transfer concurrently if a safe unit is not immediately available.
The ETP must detail any preference given to tenants who qualify for an emergency transfer. Please keep in mind this may also require the agency or landlord to edit existing tenant selection plans.
The ETP must incorporate strict confidentiality measures to ensure that the agency or landlord does not disclose the location of the dwelling unit of the tenant to a person who committed or threatened to commit an act of VAWA crimes against the tenant.
The agency landlord must make the ETP available upon request and, when feasible, must make its plan publicly, such as posting on a bulletin board. The agency landlord must keep a record of all emergency transfer requests under its ETP and the outcomes of such requests. Retain these records for a period of 3 years or for a period of time as specified in the program's regulation. Report requests and outcome of such requests to HUD annually.
Now for a question and answer segment.
When a resident requests VAWA protection, can an agency or landlord require the applicant or tenant to obtain a restraining order as documentation of the victim's status?
No, the agency or landlord cannot require the tenant to obtain a restraining order to document victim status. While the VAWA final rule allows agency and landlords to require tenants to submit documentation showing the applicant or resident is or has been a victim of domestic violence, dating violence, sexual assault, or stalking, the VAWA final rule prohibits an agency from requiring the victim to provide third-party documentation of victim status, except in the case of conflicting information. When requesting documentation of victim status or an incident of domestic violence, dating violence, sexual assault, or stalking, the agency or landlord must accept any of the types of documentation listed in the VAWA certification form HUD 5282.
Are residents and applicant files required to include evidence that management issued the notice of occupancy right?
Although the VAWA final rule does not require applicants or tenants to sign acknowledgement of receipt of the form, it is strongly recommended that agencies or landlords maintain a note or other documentation in each tenant file that indicates each applicant or tenant was provided the notice of occupancy rights, form HUD 5380 and HUD 5382, at each of the following times: at household annual recertification, at the time an applicant is denied assistance or admission, at the time the household tenant is provided assistance or admission, such as at move-in, and with any notification of eviction or termination of assistance.
It does not appear that the Model Emergency Transfer Plan Form HUD 538 contains all the required elements of the VAWA final rule. Will the property be in compliance if this Model Emergency Transfer Plan is utilized?
The model form contains only general provisions of an emergency transfer plan that apply across HUD programs. Adoption of this model plan without further information will not be sufficient to meet an agency or landlord's responsibility to adopt an emergency transfer plan. Agencies and landlords must consult applicable regulations and program-specific HUD guidance when developing their own emergency transfer plans to ensure their plans contain all required elements.
The head of household is a victim of domestic violence, but continues to let the abuser, who is not a member of the household, in the unit. The couple's repeated altercations disrupt other tenants. The head of household has claimed VAWA protection, but has refused to move forward with any charges and maintains a relationship with the abuser. Does the head of household still have the same rights under VAWA?
Yes, agencies and landlords cannot penalize a VAWA victim based on the fact that the victim still has a relationship with the abuser. However, VAWA doesn't limit the authority of an agency or landlord to evict a tenant if the agency or landlord can demonstrate that an actual or imminent threat to other tenants or those employed by the property or providing services at the property would be present if the tenant or lawful occupant is not evicted or terminated from assistance.
So that concludes the training for the VAWA. If you have any questions or concerns, please reach out to us at the HCA Partner Portal. That email address is
https://kyhmis.zendesk.com.
Thank you, Kathy.